Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss legal victories and challenges to your fundamental freedom and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, founder and chairman of Liberty Counsel, explains the latest legal issues all across this country. In the courtrooms of America, Liberty Counsel is winning the battle for your constitutional freedom.
The United States Supreme Court agrees to hear a case involving picketing outside of an abortion clinic or even any kind of communication outside an abortion clinic. Hi, I'm Matt Staver, founder and chairman of Liberty Counsel. Joining me is Matt Barber, vice president of Liberty Counsel Action. Matt, this case coming out of the northeast part of the country, Massachusetts, where there is a statute or ordinance that says that there is a 35-foot zone around abortion clinics in which pro-lifers cannot enter and speak, is now going to be before the United States Supreme Court with argument sometime coming up in the fall.
Yeah, it's good news that the U.S. Supreme Court has taken an interest in this case and has agreed to hear it. The bad news is that we're seeing an increase in these kinds of attacks on the First Amendment, especially when it comes to this issue of life. For some reason, this topic of abortion, the left seems to think that they have kind of a rule on when the First Amendment applies, when it doesn't apply, that there's a sacrosanct right for a woman to kill her unborn child, even if it's in filthy, unregulated conditions and so forth. So this is their sacred cow of the left is abortion. And again, the Constitution need not apply from their perspective.
Yeah, and the first case that I ever argued before the United States Supreme Court was on this sort of issue. It was where not a ordinance passed by a government body, but where a court ultimately imposed zones around an abortion clinic down in Melbourne, Florida. 300-foot buffer zone around the clinic, a 300-foot buffer zone around the homes of people who were associated with the clinic, and then a 35-foot zone around the actual clinic entrance itself. That case went up to the United States Supreme Court back in 1994. I argued the case. What happened is there's been a couple of other cases that have gone up to the U.S. Supreme Court as well. And as a result of some of these cases, Massachusetts decided to go even further and not have a specific tailored injunction from a court, but an ordinance that applies to everyone. And what they did in this particular case is say, this 35-foot zone around the clinic, if you want to enter that and speak on pro-life issues, you're prohibited from doing so, and you would be penalized, punished for doing so. But if you are associated with the clinic, you can enter into that zone, and you can speak your viewpoint. So it allows only one viewpoint to be presented, which is the abortion viewpoint and not the pro-life viewpoint. It's pretty obvious what they tried to do. So this ultimately was challenged. One of our friends, a longtime friend, Michael DePrimo, is one of the attorneys on this case, and the Supreme Court has now agreed to take up this case, which is good because the Court of Appeals, known as the First Circuit Court of Appeals, actually upheld the ordinance, finding that it did not violate the First Amendment. So the Supreme Court now has decided to take the case, which may be good news for the future.
I think it probably is. And the First Circuit upheld the buffer zone law, saying that it was, quote, narrowly tailored time, place, manner regulation that protects the rights of prospective patients and clinic employees without offending the First Amendment rights of others. Well, this is kind of a novel definition of narrowly tailored when they have used the shotgun approach here, kind of a broad approach, and basically said anybody with any dissenting view on abortion has to stay out, but people who are supportive of abortion are allowed in, employees and so forth. I failed to see how that is narrowly tailored.
Yeah, and in fact, the court ultimately, in upholding this below, said that you have other alternative avenues of communication, and they said you could be on the other side of the street, outside of the buffer zone, and you could yell to people that are on the other side going into the clinic. Well, you may be able to yell, but then there's probably a noise ordinance that says that you can't have a certain magnification of your voice beyond a certain decimal level. But moreover, even if you could yell, with cars passing by, your communication is going to be completely useless, and you can't hand them any literature. So if you wanted to give them a literature on life, which shows the development of the unborn child, for example, or alternatives to abortion, some clinics, some facilities that provide free services for women facing crisis pregnancies, you're not going to be able to do that by yelling across the street.
Well, the good news is I think the preponderance of bubble zone or buffer zone type cases were down in favor of the First Amendment, of free speech. And so, again, I think that the fact that the Supreme Court has agreed to take this is, if we're going to try to read the tea leaves here, and it's all, I'm always reluctant to try to read the tea leaves with especially this current United States Supreme Court. But if you're reading the tea leaves here, I think that that's probably good news that they're going to look at it.
I think it is good news that they're going to look at it. You need 4 justices to take a case. You need obviously 5, a majority, in order to have a decision in your favor. And so we know at least 4 justices of the 9 feel that there's some kind of reason to take this case. If those 4 justices were in agreement with the decision from the Court of Appeals, they wouldn't have done this. Yeah. So obviously those 4 justices, it appears, would be in disagreement and or they think that there's some kind of conflict with the other circuits that they need to resolve. And consequently, I think it's a good news because otherwise this case could have stayed there at the Court of Appeals and it would have been the law of the land for the whole northeastern part of the country. Massachusetts and New York, Massachusetts and that other northeastern part of the country would all be underneath this particular decision. So this is good news, and we'll see what ultimately happens. But certainly Liberty Counsel will be filing a brief in this case in support of the position of the pro-life plaintiffs, arguing that this is a clear violation of the First Amendment. You can't have buffer zones where you just simply say, we're going to put a zone around here, and the only people that can speak are those that are associated with that facility. It would be like, for example, saying we're going to put a zone around a particular business, and only the employees of that particular business can speak, but anybody who wants to picket that particular business, have a sign to the contrary, can't speak. And especially with the atrocities of the abortion industry that we see right now with Gosnell, with the others, you want to have more information, not less information.
Sir Isaac Newton, I think it was, said that every action has an equal and opposite reaction. We've seen a number of states strengthening laws and regulations, looking at the very corrupt multi-billion-dollar abortion industry. But the courts, Matt, I think they're human. All these judges and justices, they're all human, and they represent a microcosm of a larger culture on this issue of life, which is very polarizing. So as we see more protections coming into place to protect the innocent unborn and women from the abortion industry, we also see pushback and occurring around the country, particularly in liberal states like Massachusetts. And so President Obama said that the culture wars are so 1990s. Well, no, since he's been in office, the culture wars have absolutely ramped up.
Well, he's ramped them up. The interesting thing is he ran on the platform that he would ratchet down some of these culture wars. But in fact, he's ramped them up, whether it's abortion or the so-called lesbian, gay, bisexual, transgender et al. Agenda. I mean, he's ramped them up to an unprecedented level. Liberty Counsel, we have filed a lawsuit on behalf of Susan Pine. First of all, we represented her when Obama's Department of Justice, Eric Holder, as the head of that, came against her down in Florida, trying to silence her. And after 2 years of defending her, we won. And the Department of Justice had to pay $120,000 for its frivolous lawsuit. They were trying to use the federal government power to silence pro-lifers, and it ultimately backfired on them. Now we actually filed a separate lawsuit in addition to successfully defending her against the DOJ against the city, because the city has a noise ordinance that essentially allows virtually no communication of any amplification. You couldn't even perhaps play music on your iPod as you're walking through the area. So that suit is pending down there as well. Liberty Counsel has been actively defending pro-life and speech of that kind of nature, religious liberty, from the very beginning, since our founding in 1989. Like I said, the first case that we ever had before the United States Supreme Court that I argued was 1994, Madsen versus Women's Health Center. Continue to pray for this case. It's a big one that will be argued in the fall of 2013 and decided sometime in 2014. Liberty Counsel will be right there involved. Go to Liberty Counsel's website, lifeunited.org, to get a lot of information about the pro-life issues such as the development of the child, the resources that are available for women facing crisis pregnancies, and much more. lifeunited.org. You can also always visit Liberty Counsel's website, lc.org, lc.org. Sign up for our Liberty Alert email and also our Grassroots Action email as well, right there on the front page. Make sure to remember Liberty Counsel in your prayers and your continued and regular financial support.
You have been listening to Faith and Freedom with Liberty Counsel. We hope that we have motivated you to stand up for your faith, family, and freedom. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email updates. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.